At least I think it's Friday afternoon. I'm not sure. It could be any day of the week now. But we are joined here today for a quick Zoom conferencing with Judge Emily Miskell from the 470th and Judge Roy Ferguson from the 394th. And I want to take this moment to thank our judiciary for all they've been doing during this time period to get us up and running again. I participated in a number of hearings and trials and practices, and I'll tell you what, it does feel good as a trial lawyer to get back into the courtroom, albeit a virtual one, and start doing some of those things that we've all been used to doing. So we are very, very fortunate to have two of the best judges and the ones that are first on the scene to help other judges learn how to do this technology and get us started doing what is likely going to be a big part of our practice in the future. So without further introduction, go ahead and get started, Judge Ferguson.
Well, thank you, Crystal, and a special thanks to Crystal for putting this together and trying to rein in the two of us as we try to walk through this process. Hello, everyone. This is a new era for us. Everything has now changed, and I'm sure you, like I, are sitting somewhere strange with people and pets wandering around, trying to learn how to be a lawyer or a judge in a brand new setting. And so with disaster comes forced change, and that's where we are now in this crisis. So we have been really fortunate to have the Office of Court Administration and David Slayton just leap forward when this crisis hit and start working with all of us on how we can keep courts working. Now, we know that this audience is going to be very diverse on how comfortable you are with Zoom. I'm willing to bet there's some people watching this right now, and this is your first Zoom conference. So we're going to try to walk you through from beginning to end, telling you first how to get on so that by the time we're done here today, if you get a text that says you have an emergency hearing at 5 o'clock, you'll be ready to jump in and represent your client. We're going to go all the way through to the end where Crystal's going to take over and show you some really fine skills that you can use to present your case in the most effective way. The first thing I want you to understand is that everything you can do in a courtroom, you can do in a Zoom courtroom, in a virtual courtroom. Everything you can do here. It's just a different skill set. And I know there's some people who really don't want to do it. I suspect that Crystal is right. This is going to be around in some form or another long after this crisis is over. But what we need to teach you today is how to do all of those things here that you would do standing before us in the courtroom. You can slip notes to your client. You can whisper in your client's ear. You can show something to someone so they can refresh the recollection, and you can offer evidence right to us from the bench. So let's get started with some really basic things right up front. How did you get here? Well, you've got YouTube installed, so at least we know you can do that. Zoom is easier than YouTube, I think. So what you're going to do is you're going to go to zoom.us and you're going to sign up if you haven't already, get an account. And then you can either click resources and in the pull down hit install client, or you can just host or join an existing Zoom meeting. When you do that, it's going to pop open a window and it's going to say open Zoom client or install Zoom client ? Say yes. It is very important that you use the Zoom client and not the embedded Zoom plugin. Because if you do that, it will not have all of the features that we will be using and Judge Miskell will be showing you in a few minutes. Those things are only contained within the main client, the main app. So on your phone, your tablet, or your computer, install the app, use it every time when it asks you to join a meeting. You're going to join a meeting using a code. Either you'll get a link in an email, what we call an evite, and you can just click it, or you'll get an email with a code. It can be 9 or 10 digits, and you're going to plug that into the meeting code, and it's going to automatically launch you into the meetings. Once you do that, you're going to pop in, and as you can see, all three of us here, you can see us on camera. You're going to have a choice as to whether you want to be in speaker view or gallery view. Now, up on the top right, in the Zoom window is a little thing that says speaker or gallery view. If you click it, it's going to change back and forth. Judge Miskell, why don't you change us to the other view right now so they can see on your YouTube stream the different ways that it can show up. On a speaker view, the person, go ahead. Yes, ma'am.
I was just going to say, gallery view shows everybody. Speaker view shows the speaker big and everyone else small, and it will switch automatically as the microphone on Zoom switches.
That's right. In the gallery view, the active speaker has a yellow box around them. And so you'll just see that yellow box move as a different person activates the microphone. On speaker view, it's going to jump you to the person who's speaking, unless the judge hits a pin. And we can hit a pin and hold someone in the main screen. So as you get more comfortable with using it, you can decide which one you want. Sometimes it's nice to be able to see everybody. So you can see if the opposing party's shaking their head or nodding up and down, or, you know, trying to type frantically to their lawyer in the secret chat. So it can be useful. Now, I want to do a very basic thing real quick, and I'm going to ask Judge Miskell to pull way back from her desk, as far back as she can go. Now, when we are joining in, what your video looks like is crucial. So Judge Miskell, say something so you activate primary speaker.
I don't even know if my microphone can hear me this far away. Are you even able to hear?
We are able to hear you. You must have a high quality mic. But what we can't do if we're in gallery view is see you, because you're about the size of my fingernail on my screen, on my little tablet screen. So the first thing is, when you are setting yourself up, make sure you think about lighting and framing. And another good example is if you have a bright light behind you, whether it be a window or even a lamp. We had one where they had shiny paneling and the light was reflecting off the wall. You will go dark because the camera is trying to adjust to the brightest spot in the room. And so suddenly you're completely shadowed out and we can't see you. So think about having no bright light anywhere. And the funny thing is, although Judge Miskell has a virtual background up, and I'm going to have her speak in just a second, I can tell you where the window is in her house. Go ahead and speak.
I have us back on all three gallery views so they can see us all, because obviously I have a window on this side that has no blinds on it. So this side of my face is always way brighter.
That's right. And we've had some where one side was bright white and washed out and the other was black and we couldn't see them. So keep that kind of thing in mind. I'm going to show you one other thing that you have to watch out for that I've seen several times in hearings is this. Someone is having a hearing and they start arguing and all I can see is their forehead or maybe just their lap. So it is important to frame yourself properly. Don't be afraid to reach up and move it around. Frame yourself well. Yes, Judge Miss?
And the reason we have video is because it really helps the court reporters to be able to see your face and mouth while you're talking. And so I've had a hearing today actually where it turned out like this the whole time and we might as well be on the phone. So try to keep your face in the picture for the court reporter.
That's exactly right. Now, let's talk about the toy that everyone plays with when they first find it. And a lot of judges are using it because the OCA has suggested that judges consider using a virtual background. Now, yes, they're fun. Yes, I've seen lots of people at the beach. There it is right there. Judge Miskell showing you the, what beach would that be? Do you know?
No idea. I also found this one on the most annoying virtual backgrounds. So you're welcome.
I'm starting to have a seizure. All right, so yes, virtual backgrounds can be useful, but with apologies to the lawyers on the screenshot I'm about to show you, I am going to share screen, and Judge Miskell is going to explain that in a few minutes, so that you can see a screenshot from a plea hearing. This is Judge Kirsten Cahoon from Bernie, and she held a hearing today. Thank you for letting me use this. And as you can see on the top right, there is a virtual background being used by a family law lawyer. And when he looks side to side, different parts of his body disappear as the shine of the light in the room changes the reflection. Now, that one is a little bad, but it got worse as the hearing went on and more body parts started to disappear. At this point, we lost his nose, mouth, chin, and one whole shoulder side of his body. So that is where you have to be absolutely certain, if you're going to use a virtual background, that it does not do this. I've seen some judges where when they tilt their head to the side, their hair disappears. Or I had one where they tilt this way and their eyes disappeared, and suddenly I could see the virtual background through the holes in their eyes. A little disconcerting, a little bit like the Ring movie. But now, one more thing, and then I'm going to hand it off to Judge Miskell, and she's going to run, is I want you to think about where your camera is in the room. And I'm going to show you another shot from that same hearing. And this is where the attorney was looking the whole time he was arguing or questioning. Now, if you're the witness and you're being questioned and you're looking at the person who's questioning you, there's a little bit of a disconnect. You're not being looked in the eye. And I think, and really Crystal can address this maybe better than any of us, but I think as a lawyer, it's different when you're looking someone in the eye and they're looking you in the eye. You can read credibility better, you can judge their reactions better, and you might get more truthful answers. As judge, we have the same thing. We're supposed to look in the camera whenever we're not looking to someone for an answer. And I want to encourage you to place your camera in the room in a place where you are engaging the camera, so that even if you're not looking at the camera, you're close to it. That makes it a much more personal touch. So I'm going to turn off my screen share and turn things over to Judge Miskell for the next phase. Thank you.
Let me add one thing there. As Judge Ferguson was saying, a lot of lawyers just have different setups right now. Some of them have old cameras that they're adding to their personal computers. Some have laptops. Some are using their phone. What Judge Ferguson is saying is that if you have, a separate mic, a separate camera, and you've added them to your computer, then you have to place that camera where you're also going to be looking at your computer screen, because we get it. You have exhibits and documents that you're looking at your computer screen. But as you're addressing the court, you're also going to have to be talking to them. So you can't be looking at your computer screen and the other people speaking. If your camera is over here, you're not going to be looking directly at your court. And so that's going to be a little disconcerting as you're watching it. So even though you might have a separate computer, make sure that camera is right where you're going to be looking at your computer screen.
All right, so we talked about preparing yourself as the lawyer to be presenting your motion or whatever. Let's talk about preparing your client, because this is an area that we've had a lot of difficulty with so far. Clients, number one, practice in advance. So get on a Zoom meeting with your client before your scheduled hearing. Make sure they know how to enable their volume, enable their screen, because I spend at least the first 5 minutes of every hearing saying, your microphone isn't on, turn your microphone on, because we can't hear you. So make sure you practice with your client in advance. Secondly, make sure you make your clients practice in the location that they are going to be Zooming from in advance. We've had people Zoom with loud TV in the background that was unhelpful. Somebody appeared for a Zoom hearing laying in their bed, which is not persuasive and helpful. The window issue, if you have a bright window behind you, I'm going to try to do that. It really affects our ability to see your face. So make your clients practice in the place that they're going to be. Another thing was they can have other people there, right? So we had one where the girlfriend was trying to help him figure out his Zoom. And so there she is in the picture too. And like everybody's in the room. So just go over with your clients, be in a room by yourself, practice the Zoom so we can hear your audio and see your video. Don't have TV on in the background. Don't be laying in a bed, pretend you're in court, get dressed. And I would say, specifically go over that with your client. Don't assume that they know what to do, because when people are doing stuff on their phone, it feels casual. The other thing is some people will wear headphones or wear microphones. That doesn't bother me at all as a judge. If it helps your client hear better, to put their earbuds in to listen to the sound, go right ahead. One thing I will say is a lot of attorneys have been concerned when you sign up for a free account, it tells you that there are certain limitations, like a 40-minute maximum or some other limitations. And so the attorneys were panicking, saying, oh, well, I might get kicked off a hearing because I have a free account and I'll get kicked off after 40 minutes. All of your judges have a paid pro account through Zoom. So when we initiate and set up the Zoom meeting, all of our magical powers apply to it. So you will not, even if you have a free account, you will not get kicked off of one of our hearings that we set up. Another tip I would say is silence your Outlook. It's distracting when there's constant dings and bings in the background while we're trying to have a hearing. So turn off your Outlook notifications or close out of Outlook. And if your phone is on the table and it's vibrating, that's going to be disruptive. So think about your notifications before you get started. The last thing I'm going to talk about on the category of sort of prepping your location is the first couple of hearings we were doing, the lawyers had the clients come to the lawyer's conference room and sit there, two people in the same conference room sharing a laptop for the hearing. One time it worked fine and one time it didn't work at all because on that whatever particular laptop, it would only hear the sound of one person. So the lawyer would try to ask questions, the witness would try to answer, but we could only hear one of them. So then they booted up on a second device. So the lawyer had the laptop, the client had the iPad, but they were still in the same room together and both of them had their sound turned up on their devices. So then it just caused echoing and screeching feedback. So then we had to have the client take their iPad into a separate room. So the lawyer stayed in one room with the laptop and the client went in a separate room with the iPad. So you're perfectly welcome to have your clients come to your office if you want to. I know that you may want to prep or do a dry run with them, but just when you start the hearing, it really works best if everyone's on their own device in their own room. Let me see if I had anything else on the topic of prepping your setup. Crystal or Judge Ferguson, anything else on that topic?
I do. So an interesting thing happened in the hearing I was in today. Well, it wasn't interesting. We'd kind of talked about doing this. I don't find it combative, and maybe some of the judges might, but I don't find it combative to ask the witness that you're cross-examining who is in the room with you, what papers do you have in front of you, what are you looking at, the same way you would in a courtroom if they brought notes up with them to the witness stand. We did that today. It was very effective. It did not come off to me, at least, as combative with the attorney asking the opposing party who might have been in the room and what documents they might have been referring to while they were testifying. If you're concerned about a witness doing that, then just simply ask the question on examination. You don't have to do it in a rude or disrespectful way, but you are entitled to know if there are other people in the room with that person helping them with their Zoom chat or whatever the case may be. If there are children in the room, you're entitled to know. And if they're reviewing notes from their attorney while they're testifying, you're entitled to know that. So feel free, in my opinion, to ask that question of the witness on the stand if that is something that you feel like you need to know as part of your hearing.
I agree with that. I'll tell you this. Most of us now have developed what we're calling Zoom admonishments. And I have a list of them as well. And at the beginning of each hearing where we're going to take evidence, we read off these admonishments, letting the lawyers, letting the witnesses, the clients, everyone know what the rules are going to be. So if I'm going to let a witness in, one of the things I'm going to tell them as I'm identifying them and swearing them in is that they're not permitted to have anything in their hands. They're not permitted to be looking for anything on their computer or on their phone. They need to just sit with their hands in their laps and testify from memory. And if someone wants them to look at something, they will be asked to look at something. But I make it clear that these are the rules. This is what you can or can't do. We contemplated earlier if we had a witness who is, if you look at me, was doing something like this while they're testifying, or maybe, this number, then we might ask the witness to move away from the camera. Just move back so we can see their hands in their laps. Then we know that they're not doing anything like that. That would really be more of a control issue than for someone who is acting out already, not something that we would do prophylactically to be concerned about witnesses cheating. We're really on the honor code with a lot of our rules here. And so we're going to have to trust until we have a reason not to trust, and then we'll take steps.
So Judge Smith,
last thing I'm going to say, I found one more thing on setup. There is a setting in your video settings where you can do a checkbox that says touch up my appearance. Please check that box. I know it's hard to look at your own face on camera all day. We need all the help we can get. Oh, and then the other thing I was going to say, you might have noticed as it switches between Judge Ferguson, Crystal, and me, it takes Zoom's microphone a part of a second to catch up and switch over. So you missed that first part. And unfortunately, if you're having a hearing and you just shout the word objection, that is the first part that will be missed before the Zoom microphone has a chance to switch over to you. So I find it helpful if you're going to object or if you're going to interrupt to do a visual signal. And that way I can pause everybody or slow things down because we won't hear the first word or two when it switches over between speakers.
And let me
is if you're on a VPN, so to get on my courthouse email and our case management system, I have to be running a VPN, but VPNs drain and negatively impact your video performance. So please get off your VPN before you start your Zoom hearing. It will improve your video quality a lot.
Okay, so Judge Miskell, we have some kind of control over our clients. And let me add one more thing to that. When you're talking to your clients and you're prepping these for your hearing, I know that, and I would say this to the lawyers too, Judge Ferguson and I discussed this. One thing that we're used to in the courtroom is one attorney will object and the other attorney will almost immediately have a response to that objection. And sometimes it's just, okay, I'll withdraw that question, or never mind, I'll move on so that the court doesn't make the ruling. That's not as helpful in this virtual courtroom setting. And what I've had to tell my clients is, look, when either attorney objects, either me or opposing counsel, you have to take a break. You have to stop immediately what you're saying, because in the past, maybe I didn't admonish my clients so terribly if opposing counsel was objecting. But in this scenario, it's very different, and you're not going to get a clean record. You're not going to be able to hear people clearly. It's going to be confusing. And so I've had to tell clients, look, when either counsel objects, you just have to stop. And the court needs to go first, in my opinion. If one counsel objects, the other counsel should not just step in and immediately start arguing their response to the objection. The judge may already have their ruling. So in my opinion, what might be a little bit different in a virtual courtroom versus the real courtroom is once an attorney objects, everyone waits for the judge to see who goes next, because the judge might have an immediate ruling, and then there's no need for opposing counsel to respond. And that's what we found a little bit when we were kind of going through some of our objections. We kind of got into our old traditional mode of just arguing, and that's not helpful to the record in any way in these virtual courtrooms.
Chris, you raised another issue that I think we need to address, and this is a basic issue. It has to do with whether you mute your microphone when you're not talking or not. Now, obviously, as a lawyer, you don't want to do that because you want to object quickly and be heard. But we could demonstrate this really easily. If while I'm talking right now, Crystal, go ahead and cough a couple of times loudly, just make a noise.
I'm being disruptive. I have a lot of feedback here on your testimony.
See that what happens, and we want to, it sounds silly, but we can point out to you that it's still on her because of the noise on my side. Because of that cough, it is still showing Judge Miskell as the highlighted person. So if someone's talking and all you do is make a loud noise in your chair or drop a book or cough, or a child walks in and says, "Daddy," it will jump to your face. And suddenly that's what everyone sees, is you doing whatever you were doing, paying no attention to the proceedings. So I find that if you're a client or if you have someone else in the room, like we had a probation officer today, stay muted until you need to be heard, so that you don't keep jumping the picture back and forth from one person to another.
And I do, when I'm running the hearing, I mute all of the non-attorney participants until it's their turn. The other thing is, sometimes the witnesses, because it feels informal, will feel free to comment on each other's testimony. And so as the meeting organizer, I have the ability to mute anyone. I can turn off their video if they're making gestures. I can also exclude them from the meeting and put them back in the waiting room if we need to excuse them from the meeting for something. So we can manage that as the meeting organizer as well.
And for those of you who haven't used Zoom a lot, if you hover over the upper right-hand portion of your video, you'll see that mute option plus a little dot, dot, dot that allows you to do some other, as I just did, keep your mouse on that mute, unmute portion, and do it very quickly. The attorneys can even mute themselves if they're being conscious of what's going on, and can unmute themselves extremely quickly.
I think if you have yourself muted, you can hold down the space bar and it unmutes you while you say something quickly, and then you let up and it remutes you. So there's a lot of good. That's the thing. We don't want to overwhelm people with a whole bunch of detail, but Zoom has a lot of great features. So once you get the basics under your belt, there's a lot to learn that can improve things, but you don't have to know any of that to just get started.
So what are you all doing? It's a little bit easier for us to control our own witnesses, but what do we do for the third party witnesses, the other witnesses that are coming in that are not the parties to the lawsuit? How are we subpoenaing them? What does that look like? Where do you put them? How do you invoke the rule? How do you enforce the rule? What are the judges doing in those scenarios?
So in our county, the constables are not serving any papers that are not emergencies. So you can't really subpoena a witness and compel their appearance. So the hearings that we've had, the witnesses have appeared voluntarily. So it hasn't been an issue so far. I've gotten anything else, Judge Ferguson, that you want to add about trying to get witnesses there to the Zoom hearing?
No, we're following the same rule. If you have to have a subpoenaed involuntary witness, I don't think this is going to work the way we have it set up right now. Because number one, you can't get it served. And number two, it's not a command to appear in a place. So it really falls outside the traditional definition of subpoena. But as far as the rule is concerned, in my court, in my local protocols, my standing order on Zoom hearings, the rule is always invoked. So I am invoking the rule sua sponte on every evidentiary hearing. And what that means is there are no witnesses in my virtual courtroom until they are called and I admit them from the waiting room. So I don't have the problem with anyone else jumping in and talking or messing with exhibits, because it's me, the lawyers, the clients, and one witness at a time.
We skipped over a step there. Can you explain to everyone what the waiting room is? Because those of us with just regular personal accounts do not have that option.
Okay, the waiting room is really the feature that makes this work for us the best. What we do is everyone who enters into our court is going to come into the narthex, whatever you want to call the little room outside, and they're all going to wait there. And then essentially, we are going to bring in the people we want for each particular hearing. So I have a docket where I sit 5 criminal cases, and their lawyers and the defendants are all waiting in the waiting room. And they just see a white screen that says, you're in the waiting room for the 394th Judicial District Court. Don't leave. Wait to be brought in. And then I'll bring them in one at a time. And so when the witnesses are directed by the lawyers to join, they're going to tell the witnesses, when you come in, you're just going to be in the waiting room. And when it's your turn, that's when the judge will admit you into the room. We have a participants list. And in that list, it says people in waiting room. And so I know everyone who's there. And that raises one more issue. And I'm going to hand it off to Judge Miskell. You must tell your witnesses and your clients to sign up for Zoom or log in using their real names. I'm not going to let Captain Jack Sparrow into the room for a hearing. It's going to have to say Jack Smith. So tell the people, sign up with your real name so that the judge knows who you are and why you're there. And we could change their name if we got lost with too many people. We can change it to Jack Smith plaintiff, Jack Smith defendant in our participants list so we don't get lost. But the waiting room is what allows us to have people sign in for a hearing but not be in the hearing at the time. It's like being in the hall.
If you call from a phone, so we much prefer that you do video because, like I said, it significantly helps the court reporter. If you have more than one person just dialing in by phone, before you talk, you're going to have to introduce yourself every time because the court reporter won't know who's talking. The other thing is when someone dials in just from a phone to a phone number, In the participants list, it won't show a name for them. It will just show their numbers. So I had a hearing where we had multiple people dialing in by phone. So I'm like, okay, whose phone number ends in 0668? And then I'd rename them, and like, okay, who's 5432? And I'd rename them. So kind of logistically, whatever. But we understand that not everyone has access to video. So we, of course, will accommodate people who don't have access to video. But if you have access to video, please use video. The other thing that we have the capability to do, so waiting room, when I schedule a Zoom docket, I automatically enable the waiting room. So that's where everybody will start. Let's say in the middle of a hearing, you discover the need to confer with somebody about something. What I can do as the meeting organizer is I can create a breakout room. I can move people into the breakout room. I can move a lawyer. I can move their client. I can move an interpreter. I can move them into the breakout room. They disappear from our meeting. And then they can talk. I don't know what they're saying. And then they can either come back in or I can summon them back in. And neither of us will have heard what was going on in the other room.
Your Honor, may I confer with my client, really tired mom, in private for just a moment before we continue?
Yes, and I've been practicing with this, but bear with me as I try to, on the fly, do a quick breakout room. So I'm creating a breakout room, and I'm going to assign Judge Ferguson and his client, the really tired mom. And let's see, I think open all rooms.
And it's asking me to join, and I'm going to say yes.
All right, so Judge Ferguson and his client are in the breakout room. They can't hear what I'm saying to you guys, and I don't know what they're saying to each other. I have the ability to broadcast a message to everybody to say, come back. And so that's what I usually do. If it's been a while, I'll broadcast a comeback message and wait for them to voluntarily join, or I can close their room and they will be brought back into the main room. So they're, oh, here we go. They're coming back voluntarily.
So I got a message on my end from Judge Miskell that said everyone come back, and I was able to hit join the main session again, and it was that easy.
There is a trick to that, though, and I have seen this every single time. When you go into a breakout room, there are two options to exit. There's return to main session and leave. And if you hit leave, you are out of the hearing and gone. So hit return to main session so that you come back into the courtroom instead of going out and having to dial or reconnect into the waiting room.
Yeah, I have accidentally left the meeting before when I did not mean to do that. So be patient as well. If your judge leaves your hearing, they'll get back on. I had a situation where my home Wi-Fi went out. Everyone kind of panicked. I was texting my coordinator, please let him know to stay. I'll be right back on. So we all have to be patient with each other with these tech hiccups, so including be patient with your judge. Do we want to, is that enough about witnesses? Do we want to move to exhibits?
I think so. Let's move to exhibits because I know that there's a lot of anxiety about how we're going to offer documents, how we share them with opposing counsel. And I can tell you just by talking with the two of you and my own judges in my county, there's going to be a lot of variance from court to court. And so what are the two of you doing? And then I can chime in a little bit on some things I've seen, but my overall opinion is it all works. It all works is if everybody's cooperating. So even if your judge in your district does it a little bit differently, you're going to be fine.
Judge Ferguson, you want to start?
We can. Let's not forget before we move on that we need to talk about the chat, private chat feature with respect to witnesses.
Go ahead.
Okay, I hate to step on your toes, Crystal. I just don't want us to forget. That's really important. There's a chat feature in this that allows you to slip notes to your client. And so when you're in Zoom, and I don't know if Judge Miskell, I don't know if you can share a screen that is.
I did. I took a screenshot earlier, so I will share the screen with my screenshot. Give me a second to open it up.
All right. So at the bottom, there's going to be a little chat spot, and you can click chat, and it opens a little thing over here on the side, and it allows you to see conversations that happen outside of our presence unless we're watching for it. But what's important there is at the bottom, there's going to be the word everyone. That's what you're going to see. If you type a message, when it says everyone can see it, including the judge. But what's important is that you can choose that, click that word, and select the name of anyone in that room, opposing counsel, your client, anyone. First thing, don't select the judge and whisper to us in private. That's a no-no. Second thing is, you can choose your client and then you're slipping notes back and forth and no one else can see it. But remember, you cannot slip a note to someone while they are testifying. So if your client is in the process of being questioned, do not send them a chat message saying, say yes, don't forget this, don't say that, just like you couldn't whisper your client on the stand. And never can you do that with a witness. Never are you going to be slipping notes to a witness while they're testifying, ever. So it's a very useful feature, but I want to caution you again, be very careful before you hit send that you look at that designee line and make sure that it doesn't say opposing counsel or the judge or everyone if it's intended to be a private message for your client.
And I will also say, attorneys have asked me, well, then how is that chat preserved and is it discoverable? And here's my position. It's not a part of the record. The record is only the court reporter's transcripts and the exhibits that are admitted into evidence. I'm not saving the chat. The chat is not going anywhere. Use it or not at your own risk.
My protocol actually says the court will not save those chats, and I have the chat save feature turned off. So no one can save that chat and no one will save that chat. It is going to disappear when the hearing is over and no one's going to see it but you. Now, you wanted us to move on to exhibits. I did all the talking right there and jumped in. So Judge Miskell,
yeah, no problem. So that actually leads into exhibits nicely. So working with exhibits, obviously Zoom is not ideal for a document-heavy final trial. That said, that's not really what we're all hearing right now. What we're hearing right now is TROs, protective orders, temporary orders, urgent things. For the most part, I am not hearing final trials unless people want to and we have time. But for our purposes, for temporary stuff, if you need to work with documents, what we have said is email them beforehand to the court coordinator, copying both sides. Now, different courts have different policies about this. Some courts are publishing written Zoom policies that say something like, you've got to email them to the coordinator by noon the previous day. My court has not been that formal about things. We've just said, if you don't have it in an hour or two before the hearing, my coordinator may not have seen it and may not have saved the exhibits, and then you won't be able to use them. So what happens in our court is that if you email the exhibits to the coordinator, copying both sides, she will save them to a Dropbox that I and my court reporter have access to. And then in the hearing, and we ask that you descriptively name your files. So if you're sending the coordinator 3 PDFs and 5 JPEGs, label them M1, M2, M3, M4. And then when you get ready to use them, I enable everyone being able to share their own screen, but not everyone does that. So you can either open it up, share it on your own screen. So at the bottom, there's a button that says share screen. It'll pop up a box that'll have all your open windows on it, and you select the window you want to share, and it'll share it with everybody. Please be aware of what things you have open. If you have tabs open in your browser of sensitive information that you don't want us to know what you're Googling, close those out before you share your screen. Some judges are turning off the ability for participants to share their screen. And so in that case, you would have to ask the judge, please open and publish M2. So either way would work really fine. I don't care. I'm letting everyone share their screen until it becomes a problem, and then we'll revisit it. And that way, anything that's admitted into evidence, my court reporter already has, and then it's just easy on her end. If something comes up in the hearing that you couldn't expect to use, like a rebuttal, you can use the chat function that I shared. Let me see if I can reshare my screen. Okay, I'm going to share my screen again. All right, so down here, so this is the chat window. It will open up on the right side of your screen. This is what Judge Ferguson was talking about earlier. You can chat to everyone or just to one particular person. And then there's this button here that says file. If you click that, it will let you send a file to everyone or to one person. And so that is a way that you could publish a new exhibit for the first time in the middle of the hearing. Now you would have to alert me to the fact that you're doing that so that I know to save that file to the Dropbox so it's preserved for my court reporter. The other important thing to know about trying to share a file during the Zoom hearing using that chat function is it only lets you share a certain types of files. So PDF, JPEG, MP4. I tried to share a Word document with someone, it doesn't work. So that sharing it through the chat function in Zoom should really be sort of like a last resort process. Thoughts either from Crystal or Judge Ferguson on that?
I've been looking over here, watching the chat through YouTube and seeing some of the questions. I know that it seems like this is really complicated, and I can see that there are some people sort of lamenting. Someone even said they wanted a Zoom for Dummies course. The reason it feels that way is just because you haven't done it. I mean, every one of us drives a car, and we all remember the first time we got in the car and didn't know what to do, and it was terrifying, and so we were afraid. But now you do it without even thinking. Everything's automatic. You don't think about hitting the blinker, you just hit the turn signal. Same thing's true with e-filing. When we first started e-filing, it was intimidating. We may not have known how to do it. And now everybody e-files. Even email, for some of the older people in here who are complaining that they don't know how to do any of this. When email started, there were a lot of people who were resistant to it and everything had to be fax or letter, and now everybody emails. So the trick to this is exactly what Crystal said at the top. Just use this system and practice with it. You don't have to just use it in court. If you want to talk to Judge Miskell about going out for drinks when this is all over, or how she's homeschooling, or whatever it is, use Zoom and connect and practice. Use it to talk to your family members and show pictures of your kids, since we can't go see our grandparents anymore. Practice with it that way. The files feature is exactly what Judge Miskell said. It is not complicated. It's actually very simple, and there aren't that many options. It's just new to you. So those of you who are getting a little bit sweaty over here in YouTube about how complicated this seems, I promise you, we've only been doing this 2 weeks, if that, and already we're very comfortable with it, even though we learn something new every day. So yes.
And I will say the most senior judge in my county was on a Zoom meeting with the rest of us, zooming like a champion. So everyone, you just give it a try. You'll see that it's very easy to get started at a basic level, and then you can learn features and go from there.
Right. There has been a question about, let's get back to your question about files. We are using Dropbox, and we're using that for exhibits that everyone anticipates using in the civil cases. In criminal, it's a little different. But we've been asked a couple of times, what about things we don't want them to know we have? This is temporary orders, and there's been no discovery. We don't want them to know that we have the recording of the voicemail message. We don't want them to know that we got the picture off the cell phone of the chat of him with his mistress, right? Okay. No, we're not going to make you put that in Dropbox so everyone can see it. But what I'm going to ask you to do in my court, and Judge Miskell can answer for hers, is I'm going to have you create the PDF, and I'm going to have you email it to the court coordinator, and she's going to put it into a private Dropbox just for the court. And it's going to stay there unseen by me until it comes up in the hearing. If you don't bring it up, I'm never going to see it. It's not going to go in the record. But we're going to protect your ability to represent your client, and we're not going to interfere with your ability to cross-examine and impeach just because we're using Zoom. So I want to put that concern to rest. If you've got something you aren't required to disclose before the hearing by either a scheduling order or a standing order or a discovery request, yes, you can PDF it and send it to my court coordinator for me, and we will protect that issue until you're ready to use it. Judge Miskell, what are you doing in those situations?
I'm not basically in this time frame where we're using Zoom to hear urgent matters. If your matter is urgent, this is just taking away some of your ability to ambush people. If you want to preserve your ability to ambush people, we'll happily give you a setting in May or June when we're able to get back into court and do it. So we don't have the administrative bandwidth to manage on our end which exhibits are super secret and which exhibits are for everybody. And so we are just requiring you got to email them in advance and copy both sides. And who knows, that may result in settlement. So,
this raises a really important issue. Yes, every court has the same program. We all have the same features and the same license of the program, but we are not all handling it the same. I'm from a rural area. Bandwidth is not an issue that would ever cross my mind, nor would storage be. My Dropbox is 20 gigs. I can't fill that with the number of cases I have. So what I strongly urge you to do is reach out to the coordinator of each court and see if that judge has their own set of protocols, because we probably do. I know that I have seen 10 different versions of almost identical, but not quite protocols in all these different courts. One little thing, I'll give you a great example. In my court, the documents had to be put into the Dropbox by 5 o'clock the business day before the hearing. I just saw one today that was 4 o'clock, 2 business days before the hearing. Otherwise, the language was the same. Now, if you don't know that and you submitted at 4:30 the day before the hearing because of how I did it in Judge Miskell's court or whoever that was, you don't get to use that evidence because it was untimely produced. So check with your coordinators, make sure there's not a local protocol that you're going to run afoul of unwittingly.
and I know it's frustrating to try to keep track of like 20 different sets of rules, but it's a function of each judge is learning and growing and getting more efficient at their own pace in their own way. And so as we do this, I was doing things one way, and then as I've got more hearings under my belt, now I'm doing them a different way. And we're trying to help with how troublesome that is for you by having our coordinator be very responsive to questions. So I'm sorry that you have to keep track of 20 different sets of rules, but not every judge is as capable in the same way at the same thing as every other judge.
Well, and so let me say that in the hearing that I practiced in today, what we did was we put all of our exhibits in Dropbox, and there's a few questions on YouTube. We are gonna get to the part where you share exhibits, including, videos, pictures, things of that nature, and how we're doing it. But we were doing it the way I think Judge Ferguson is explaining he's doing it in his district, which is we created a Dropbox file that was shared between counsel. We did it 2 days in advance, and we were able to see which exhibits we agreed on and which were going to be a fight in court as to whether or not it was admissible, whether or not it contained some things on there that we didn't want the court to see. The ones that we agreed, and my understanding is they do this in federal court all the time, that maybe our state civil courts are a little bit different than federal court, but it really, as the judges were saying, you're going to lose that ambush capability, but is that really so bad in our hearings? It probably will lead to some settlement. When opposing counsel knows what evidence you have, they're going to have serious talks with their clients about moving forward. But I didn't find it cumbersome at all to put those exhibits in a file for opposing counsel to look at ahead of time. We were able to agree on some exhibits, which moved it along a lot faster for the court, and we were not able to agree on other exhibits. But we shared it in that Dropbox link. Everybody, counsel and clients, had the access to it so they could review it ahead of time, so that during our hearing we said, okay, now client, you've looked at what's been marked as respondent to exhibit 1. Is that a picture that you took? Yes. That the client was familiar with it, because again, the hope is that they're not going to have documents in front of them. And so we're going to ask the clients to look at those exhibits ahead of time, as well as counsel. So I've used Dropbox exclusively. What I know about Dropbox is that it will keep record of anybody who gets into that file and who makes changes in that file. So if you have concerns about a client or opposing counsel altering your exhibits in any way, that is recorded by Dropbox. I can't tell you I'm as familiar with other materials, but what Judge Miskell was saying, if you have that concern, or if a court has that concern, then you can email it to each other. That doesn't change your exhibits at all. Now, in some courts, they're not going to allow you to admit exhibits that haven't been produced to the other side ahead of time. Today, we practice where that just might have to happen, where a client had made a change to an exhibit that we'd already exchanged. In family law, it was an income and expense sheet. and we exchanged it, but the client had a couple of changes. And here's how we worked through it. In the middle of the hearing, the client was putting on the exhibit. He decided he wanted to make a change. He made the change. Opposing counsel emailed it to the other opposing counsel. That person is sitting right in front of their computer. We know they are because they're on a Zoom conference. He looked at the changed, amended exhibit, approved it, and it was offered. Does it take a little bit longer than it does in the courtroom? Yes, but it still worked. And instead of using the Dropbox, they used email to each other in real time, and we got the exhibit offered. So it's just going to take a little bit of time, some flexibility, and getting to know your courts and how they're going to work. But what I have found in the last 10 days is that everybody, including our judges, are being very flexible about how people are learning and how people are using these exhibits. And you're all going to learn what works for you. The courts are going to learn what works for them. I do want to say that I've received a fair number of procedures and protocols for virtual hearings in different district courts. And we are going to put those up on the family law section's website the way we did the court orders. They're not up yet because we're trying to separate them from court orders on one side to procedures on the other side, which are clearly not court orders, but protocols. And so we'll have those all up on the website for you. Got to give us some time. And some of those we've just received in the last 1 to 2 days. And those of us who are working on these things are doing so while also trying to run our practice and help our families and homeschool our children. So we're all in the same boat together. And I have found that that's caused a lot of goodwill and grace to both our opposing counsel and our courts. So just hang in there. You'll get your exhibits offered, and it's going to be different from judge to judge, just as it is currently. It was always different with all the different district court judges. And so it's going to be a little bit different from judge to judge, but I encourage you to do what Judge Miskell said and call the coordinator and ask.
And don't call because she's not in the office, but
email.
Last thing I want to say about exhibits is people have asked a lot of questions about certified copies. It may be that clerks are not giving out certified copies right now. The Supreme Court has signed an order authorizing us to relax our standards for evidence. And so if your only objection to an exhibit is that it's not a certified copy, we are authorized to relax that, and we will. If you additionally also have legitimate objections about its authenticity, go ahead and raise them. But if your only objection is that the copy is not certified, we understand you may not be able to get a certified copy, and so we're relaxing that. Same with business records affidavits. So for example, my dentist is closed right now. She canceled my appointment. So I would have no ability to get a copy of my dental business records from the dentist. The rules require an affidavit and or that they be provided to the other side a certain number of days in advance. If you've substantially complied and done your best, and the reason that you can't follow the rule is related to the disaster declaration, we again are empowered to relax that. And again, if there's a legitimate complaint about the authenticity of the exhibit, feel free to raise that. Judge Ferguson, is that how you're handling it as well?
It is. And remember, there are a lot of judges right now who are saying they're not going to do any final contested hearings for the next month. They're going to wait and see if the declaration expires and they can go back to working in their courtroom. So a lot of them are saying the only evidentiary contested hearings I'm going to have are TROs, temporary injunctions, and temporary order hearings. And then little things like motions to compel and the little ones, but summary judgments, maybe. Those are non-evidentiary, but they may be willing to have them. But when it comes to a lot of the evidentiary things that Judge Miskell's talking about, that everyone gets so up in arms about with a I got you on your business record timing, that's not as great a concern when we're looking at temporary orders in some of these interlocutory or early litigation hearings. So I'm not sure how big of an issue that's going to prove to be, because we're going to hear the evidence for our temporary orders hearings. We're going to let it in. We're going to hear it. We're not going to allow COVID-19 to keep us from looking out for the best interest of our children and our courts. If you've got someone who says, I'm going to give you a 3-day full-blown evidentiary custody trial on Zoom, I have no idea how each judge is going to handle those kinds of evidentiary situations. I don't intend to do that unless this drags out interminably long. which we hope it won't.
Real quick,
quick word about timing. It's about 4:57. I have one more section that I wanted to go over. Can we go until 5:15 or do we have a stop at 5?
No, we don't.
Okay.
But these poor people, we can talk all night. Everyone grab a drink, sit around. We'll be talking all night. But before we move on to the next topic real fast, I just want to say somebody asked about how to turn off your sound on Outlook. You go to Files, then to Options, then to Mail and Message Arrival. You're going to have to deselect Play a Sound when on Message Arrival. And that's how you're going to turn off your sound. And please do. We hear so many dings when people are on hearings in Zoom. And it's everyone usually receiving the same email from the state bar, I think. But we are going to move on because there have been questions about this. Can you talk about, we touched it a little bit. The next two subjects are conferring with your client privately and interpreters, because people have asked a bunch of questions about how we're doing interpreters.
Okay, so I think we covered conferring with your client because that was the breakout room and that was your private chat, use at your own risk. Let's talk about interpreters. This is actually really cool. So Zoom has an interpreter function built in that does simultaneous interpretation. So I have been on a training Zoom with our interpreters to train them how to use it. We're all up to speed. They love it. I love it. I think it works better than the old way of doing it in court. How it works is if I, as the meeting organizer, enable interpretation, then at the bottom of your screen, there will be a globe. And you can click on the globe and you can pick which channel you want to be on. You can be on the English channel or the Spanish channel, or if it's Chinese or Russian, whatever it is. You pick the channel that is your comfortable language. And the interpreter can toggle back and forth. And so as I start speaking in English, the interpreter toggles over and starts translating immediately live. And none of us can hear the interpreter except the people on the Spanish channel. And then when the witness answers in Spanish, you hear the person that's not on your language. So I would hear the Spanish witness at about 20% volume, so I can still hear tone. We can still monitor if the interpreter and if the translation is an accurate one. And then I'll hear the English translation at full volume. And this means also the court reporter is able to focus on only writing down what the interpreter says, because sometimes witnesses answer in English and Spanish, and that makes it hard for the court reporter. So you have live real-time translation. The other benefit is you only need one interpreter because all of the witnesses or parties or whoever needs to be listening to Spanish can all be on the Spanish channel. So it's a little tricky to do the first time. And so I've been helping the judges troubleshoot that. So be patient. But it's a fabulous feature. And I have high hopes that going forward, if we have a hard to find language, that I might be able to use an interpreter from Houston or from El Paso or from wherever, because with this Zoom interpreter technology, we're not limited to people who can drive to my courtroom. So be patient with that one, but it's super cool once you're able to use it.
There are a couple of tricks that you have to know, or you're going to find there's a glitch and it's going to distract you. One thing is, once it's been activated, let's say that Judge Miskell activates the Spanish translation. Down at that globe, it's going to have off, English, Spanish. Once it's been activated, you have to choose one or the other, because if you stay on off and someone talks over someone else, it knocks their volume down to about 20%. And now you won't be able to hear someone else's full volume, and they're at 20%. So once someone says, we are activating the interpreter for this hearing, you must go down and select English to continue with the hearing. The second thing is, in relation to the breakout rooms, if you're in a hearing that has Spanish, English, or any other language interpretation turned on, and you exit to a breakout room and come back, when you come back, it's effectively like rejoining the meeting from a separate meeting, and your language selection will be at off, even if it was at English when you went into the room. So when you exit and come back, you have to immediately hit that globe and choose English. If you forget, and you will at first, and suddenly you realize you can't hear someone, I want you to click in, oh, that's right, I was in breakout. Go down, hit the globe, you'll see it's on off, and select English again. The place where I have found it to be so wonderful is, yes, for witnesses, it's very handy, and it's quicker because they can do simultaneous. But where it is glorious is when you have a Spanish client sitting at the table with the lawyer while other witnesses are testifying, because that interpreter will just running translation of everything that happens, the judge, the lawyers, the witness, everyone, full speed. You won't hear it, but the people who only speak Spanish will. So now you don't have to have two, one for the client and one for the witness. It's just a constant running stream. And I really think that our Spanish speaking litigants are going to feel better served in court through this interpretation process.
Somebody asked on YouTube, is that a certified interpretation?
It can. We don't always have the luxury of having a certified interpreter because we don't always have one available. So Spanish, yes, we have certified interpreters for Spanish. Sometimes we have to make do.
Even if we don't, we can use the OCA Spanish interpretation for certain hearings. So if you're going to have a 30-minute or 45-minute or less hearing, and you can't find a certified interpreter, you can request that the OCA provide an interpreter for your hearing. They will log into Zoom from their office in Austin, looking just like one of us, and they'll do the interpretation certifying. Leo and Maria do a wonderful job doing that for our hearings.
Yeah, Leo's the one that trained us on how to do it. They've been doing an excellent job helping out. I saw a question in the YouTube comments. I mentioned this earlier, but let me say it again. When we create the breakout room, we can send anyone into the breakout room, including the interpreter. So if you as the lawyer don't speak Spanish and your client does, and you need to confer about their Fifth Amendment privileges or something, we can send lawyer, client, and interpreter to the breakout room. They will talk, we won't hear them, and then we can bring them back. And yes, if you're having technical difficulties with your interpretation, it's 99% of the time, is everyone on the channel you're supposed to be on? If you're on English, are you on Spanish? Double check your channel. So if you're in the middle of a hearing and the court is having trouble, suggest that everyone check their channel.
There was also confusion in the questions on YouTube about the court's ability to see the secret stuff. And I want to clarify what I said before. When it comes to a breakout room, when you're in the breakout room and we send you out, we have a thing that tells us you're there and gives us the ability to pop into the room. We don't have the ability to listen in. We don't have the ability to peek in. If we came in, our picture would appear and you would see us there. Like I told you, my local protocol says I will never do that. I'm sure that all the judges are feeling the same way about that. So that situation, breakout, yes, the court has the ability to come in, not to see, but to pop into the room. The private chat is different. We do not have a functional ability during the hearing in any way to peek into your private chat with your client. It is private. And we won't see it, and we don't even know it's happening. They could be chatting right now, and I would have no idea because it won't show up in my chat. So
We're not going to tell you what we're saying.
I believe you. So when you're in that private chat, I don't want you concerned that the court can see and just promises not to. We can't see it. It is private. Just like you were slipping notes at the table, we can't see those either. So I hope that clarifies some of those discussions that we had there on YouTube.
So the second to last topic, the last topic, we're going to give a few little practice tips, but we've kind of touched on this as we've gone through each subject matter, which is the different matters, how we're going to do things like giving notice, the difference between TROs, protective orders, temporary order hearing, contempt, agreed matters, prove-ups. How are the courts handling those different things that obviously clearly have, a protective order hearing is very different from a temporary orders hearing, which is obviously very different from a final hearing, which I agree with you. I think most judges are going to defer until such time as we can get back into the courtroom. But how are you handling those different things? And particularly, I've gotten a lot of questions this week about agreed orders and how to get those signed by the court. What are you guys doing?
Judge Ferguson, run through how you're handling things, what you're setting, and how you're dealing with it, and then I'll do the same.
Sure. The Supreme Court issued an emergency order that allows us to consider evidence in different formats from what we used to do. For example, we can take evidence now by affidavit only. And so if you have something that requires a little bit of prove-up evidence, or let's say even better, let's say, Crystal, you've got an agreed order that you want just entered, but there's really something you want to get on on the record in support of that order for whatever reason, we don't have to have a Zoom hearing and get everybody in front of us on camera, because the Supreme Court says we can take it by affidavit. So here's what I'm suggesting to the lawyers, and I've asked my lawyers to do this as well. If you have something that you need evidence on the record, but you don't need to get everybody to put on their suits and take showers and makeup and get on Zoom, you can request a consideration upon affidavit or upon submission. And we will, I don't want to speak for every judge, but for myself, 100% of the time, if the parties agree to submit affidavits in lieu of live testimony, I'm in. So that's something we won't be able to do when this all expires, but for now we can. Anytime I can do something on submission on affidavit testimony, I'm going to try to let you do it. And I'll tell you this, I don't want you to feel cornered either, because if I got those affidavits and there was something that I was not comfortable with, I can then just go ahead and schedule a Zoom hearing. I'm not bound to rule on the affidavits, but if I can, I will. So we're all trying to do whatever we can to make your jobs easier than they were before, based on the emergency order of the Supreme Court. Judge Miskell.
One thing I did want to clarify also, because attorneys have had a lot of questions about this, is notaries and affidavits. So just remember that Chapter 132 of the Civil Practice and Remedies Code allows you, Texas law says you can use an unsworn declaration in place of an affidavit. You can do that for everything, except there are a couple of things that the Family Code prohibits that. One is a waiver of service. And I think I recall that you can't do it with a relinquishment of parental rights. But everything else, if the statute says affidavit, CPRC Chapter 132 says you can use an unsworn declaration in place of the affidavit. Okay, so for my court, what I'm hearing, in Collin County, we've issued our procedures that we're not hearing any agreed matters. So if you have a divorce decree and it's agreed, just submit it through the e-filing system and we sign it. I don't require an affidavit. I don't require a prove up. That's my normal practice anyway. I never, even before this, required any type of prove up or affidavit. So that continues. We are not, so, and let me just make it clear, because people get confused when I say agreed order versus default. Those are two very, very different things. If you have an agreed order that's signed by everybody, submit it, we sign it, you're done. A default can't be done. So here's the controversy. There's abundant case law that says default judgments have to be on the record. If there's no record, that's instant reversal. The Supreme Court order has authorized us to accept evidence by affidavit that we normally would not. So you could argue that you could do a default by affidavit. Certainly that would be consistent with what the Supreme Court's order says. I am not doing defaults because we don't urgently need to do those. So unless there's some sort of like grandma has the kid and no orders and can't get the kid medical treatment or whatever, then we might go ahead with a default. But absent that, defaults usually aren't time sensitive. So for the most part, I'm just waiting on those. But agreed judgments, just submit them, you're done. And then similarly, I'm hearing very few final trials. For the most part, we have limited capacity. We are operating at about 1/3 of the number of cases that we're normally able to hear. And so those spots go first to emergencies. And then if we have time left over, we fill in with whatever non-emergency stuff we can hear. I've gotten a lot of questions about enforcements. Okay, you can't order someone to appear in a Zoom chat. You can't, how am I going to hold them in contempt? The bailiff's at his house. You know, I don't think there's any way to do contempt enforceable proceedings by Zoom. So I have heard an enforcement, but it was clarification and judgment only. Because again, you see the logistical difficulties we have. Order to appear, and then I'm going to sign a capias, and then the constables aren't going to serve it. So, you know, we're just sort of waiting on that. And then lastly, I did want to respond on submission. If it's something easy and basic, I will take it on submission. If I get an 18-page submission from the petitioner and then a 21-page response from the respondent, it would literally take me less time to have a hearing than to try to go through that and match up all the things. So I haven't done most things by submission because, again, agreed orders, I just sign them with no further proceeding necessary. Contested things, we've been doing Zoom on what we can fit in.
And I will do defaults. Anything that will move a case along, I'm happy to do if we can. If it's a simple default and it's not going to be something that is also requesting some extreme remedy, then for me, I'd be happy to do that with someone submitting an affidavit that lays out all the necessary evidence, or better on Zoom in 10, 15 minutes. The issue of contempt, I completely agree. We can't hold a contempt because you can't get them there with a show cause. Show up at 1 o'clock digitally, I'm not sure that's even a thing. But I will do enforcements that don't have contempt requests, and we'll just do it through the other service, the other notice, and we'll have our Zoom hearing the same way we would do anything else. I think we're in agreement on everything else that matters for today. I will say, just remember, know your judge. Every court's different about what they require for submission of agreed orders. So make sure that you know the court that you're going to. Are they going to require evidence? Are they going to require an affidavit, live testimony, or are they doing what some judges are doing and saying nothing that's not emergency will be considered, not even approved of? Everything gets pushed off.
The last thing I did want to add is about notices. So we are dealing with things that were filed and set before this disaster time. We have a plan for people who have already been noticed to appear at our courthouse. But for new notices that I'm signing, TROs that I'm getting now, I am crossing out the part where it says appear at 2100 Bloomdale Road. And what I'm instead writing, and I have this sample language on my website, which is judgeemily.com, but I believe you need to give all the information in the notice that someone who got no other information would still be able to participate in the Zoom. And so to me, that means the date, the time, a phone number to dial into Zoom, and your meeting ID. So for example, what I might write in on a TRO is this hearing will be held on March 27th, 2020 at 4 p.m. by remote appearance. To appear by phone, dial 555-123-4567. And enter meeting code 987654321. To appear by video, contact the court at 470@co.colin.tx.us at least one business day before your hearing. And that way, someone who is served with that has everything they need to do to be able to actually appear and participate in the Zoom. And so that to me is sufficient notice to go forward with a Zoom hearing. Some judges are saying they're only going forward with Zoom hearings when everyone agrees to do a Zoom hearing. I am not doing it that way. We are going forward on things that we believe can be resolved by Zoom hearings. So just because one party objects doesn't mean that's a get out of jail free, we don't have the hearing objection.
I concur. We're doing the same thing. We have an order setting hearing that is created for Zoom, and it orders them to appear before the court in the virtual courtroom by using the following connection options. You can do it this way. You can call in. So it is order language for us. And then attached to the order is the protocols on wear clothing. Here's how you show up. Here's what you have to expect. So they get all of that together served on them as the order to appear. There's no argument they don't know. And I think we even said in the protocols, if you can't do any of these things, contact the coordinator and let them know, and we'll see what we can work out. We are not relying on agreement at all. There was a question in here a moment ago from Alan. I think he said, would you be willing, Judge Miskell, to do a contempt if the parties agreed to the setting and requested a Zoom hearing for a contempt?
No, I'm not doing contempt by Zoom at all.
I don't plan to either. I don't see that as an essential or emergency thing. If it has to do with they're not turning the child over, or there's something crucial that we need to address, that we can address right away. But the question of whether somebody's going to jail or not is not something we're going to take up on an emergency basis.
That's the other thing. We can't put new people in our jail unless it's an emergency, because we don't want COVID in our jail. So even if you had a contempt, we're still not introducing new people into the jail that don't need to be there right now. So I did see, this was on my list of topics to cover, and I saw a question about it. Talk about open courts and the YouTube stream. So
go on to that. Can I just add something about motions and orders? I need a little second to brag on my section and my council members. We had some requests from judges around the state. As you know, the section is responsible for drafting and publishing, with the help of Texas Bar Books, the Texas Family Practice Manual. And we have an ongoing team of lawyers that consistently write and edit those forms. And that committee got into gear, led primarily by Chris Rampelmeyer out of Amarillo, and they work their tails off. And you section members will be receiving an email here in the near future with a form, motion, and order of the various things that Judge Miskell and Judge Ferguson have just been talking about. A motion to have this video conferencing, a Zoom hearing, and an order, what that looks like, some protocols. Like all things in the Texas Family Practice Manual, it is meant for you to use to adjust to the court that you are in front of. So as Judge Miskell and Judge Ferguson were saying, it's not going to be the same in every jurisdiction. Some judges, if there's an objection, aren't going to make you do a Zoom hearing, and some are. This is just meant to be practice and help for those courts who don't have motions and orders for you to look at or for you to adjust to your particular case. But as a courtesy to our section members, you will be receiving an email of a sample form and order that includes, I think, everything that Judge Miskell and Judge Ferguson were just talking about, for things for you to include in your order to appear, and what that Zoom conference will look like, the protocols for that courtroom, how you exchange evidence ahead of time. And so I hope you guys find that useful. And I really do want to, again, applaud Chris Rampelmeyer and our form book committee, because they have been working tirelessly on that to send to you all. And, you know, it probably will be a permanent member of our Texas Family Practice Manual from here on forward. So I want to let you guys know to be on the lookout for that.
All right, Judge Ferguson, do you want to summarize our open court's duties as members of the Texas government?
Surely will. One of the first concerns we had when this all started up was we're not allowed to have star chambers. We're not allowed to have secret courts. Everything has to be open. The Texas Constitution has an open courts requirement, which means anyone has to be able to walk in and experience any court hearing, other than a few that are really special, like juvenile cases, or if the judge makes specific findings that we have to close the courtroom and there's nothing else we can do to protect the people inside. And so we had to come up with a way quickly to keep our open courts while still doing business, because the Supreme Court can do a lot, but they can't set aside the Constitution temporarily. That's not something they're going to do for us. So we were trying to figure out how, without a central location, and if courts close, not just court hearings, but courthouses close, then how could we have open courts? And that's when this idea came up. Well, why don't we just adapt what some other states are doing and broadcast? And so we've got it set up where you can broadcast to Facebook or to YouTube, although Facebook requires a password and membership, so it's not quite as open. But with YouTube, what we're doing, and what Judge Miskell is doing right now, is we are streaming live to a separate YouTube page that each court is creating for themselves if they're participating this way. And it will go live and we will let people watch. And as soon as it's over, it's deleted. And so there is no recording staying there for people to come and watch at their leisure. You're either watching when it happens, the same as if you walked into the courtroom and sat down. And then when it's over, it's gone. And so that is our primary method of making sure that not only do we maintain the open courts and the transparency level we've always had, but we're implementing that even more. I do want to suggest to all of the family law lawyers watching that when you have a case that has something so sensitive that you feel like it should not be broadcast on television for anyone to see who wants to see it through YouTube, you need to let us know. You can request that the court, let's say you're about to call a child witness, and this case is going to be about some really graphic things. Maybe there are some SANE exam photos, and you really don't want those to be out on YouTube. I can tell you, neither do we. That's not the goal here. And so you could approach, or actually you can't approach here, but you could tell us you've got a witness coming up and that you believe that the court should consider closing the courtroom for this portion of the testimony. We will go through the required steps. And if you can prove to us the two elements that have to be proved, then we may agree to stop the YouTube stream, allow the testimony or evidence to come in, and then we'll take a moment and we'll restart and we'll continue with the hearing. But we can't just not be open. It is unconstitutional, and we're not going to do it. Now, I do know there are some courts, San Antonio, I think, included, who's taking a different approach, and their interpretation is that sound alone, audio alone, without video is sufficient. And so what they're doing is setting up a call-in number. And so someone could call the court and say, I want to watch the hearing at 1:30 in this case. And the coordinator might give them a call-in number and say, you can call this number at the scheduled time and you can listen. So different people have different evaluations of that. Unless Judge Miskell knows something I don't think we have any guidance on this yet from above. And so each court is just trying to do their best to evaluate their interpretation of what open courts really means. Many of us, you're watching it now.
Well, and the questions consistently are, and I think it's fair, and I don't know that there's anything we can do about it. So what? So you've invoked the rule. In a real courtroom, we know that it's working. In a virtual courtroom, that's
actually, you don't. We have people cheat on the rule all the time and text witnesses from the courtroom. So if you think the rule is secure in a regular courtroom, it's already not. So, but go ahead. I know what you're about to say. Keep going.
Well, sure. I mean, obviously people have cheated since the beginning of time, and we know that they might, and they know that they try, but being in person certainly cuts down on that somewhat. And in family law, I think, and I've talked to lots of judges about this. What we often have are these shadow advisors, right? And I don't think that my concern trumps the constitutionality of the open courts provision, but I think it's a real concern. And I think what we all need to realize is that we've been at this for less than 10 days, and we don't have all the answers today. But I think it's fair that we have this back and forth and understand. For all of us who practice in family law, we have a million shadow advisors telling our clients to do X, Y, or Z, or to proceed this way in their case and their trial and their hearings. And 90% of the time, those people are too lazy to get off the couch and come to the hearing and watch it. And I've been telling lots of people this, there's got to be some virtual equivalent to open courts to getting in your car and driving down to the courthouse, something that makes you do something more affirmative than just sitting on your couch in your pajamas and clicking on one day. And I think that's where my concern is, because even if it's not necessarily as personal as child abuse or sexual abuse, allegations of affairs and things like that are just so personal, and they involve third parties who aren't parties to the lawsuit. And this is a serious concern for family lawyers. And I don't know what the middle ground is there.
So I have two thoughts, and I don't know if this is an issue on my end, but Crystal, your volume went down, and if it's on my end, I apologize, but I could barely hear you. So two things. One was the rule. So when we put witnesses under the rule, we have them in the waiting room like we talked about. Now, can they watch it on YouTube? Sure. But here's the thing. For the most part, you've heard us say that what we're hearing every day is temporary stuff. It's temporary hearings, interim stuff. So it can be fixed later. If there's a rule violation, you're still going to have a final trial. The second question that comes up all the time is, how can you prevent people from recording things that are on YouTube? Of course you can't, okay? But if you look at the bottom right of this YouTube stream, you see a little watermark that says do not record. So if someone does record it, it's got that on there. We delete it as soon as the hearing's over, so it's only available live. And I also changed the description to say recording is prohibited. So again, we still have a problem in real courtrooms where people come in and record stuff on their phone. So if you think that by being in a physical building, we automatically have magical powers to control people's behavior, we still don't. And then the other thing is the constitutional value of having the public be able to monitor their government's performance, especially in times of emergency. Especially in times of emergency, we want to make sure people's liberties are preserved and not trampled on. So it's important now more than ever that our courts are open to the public, that the public can monitor our performance. And yes, it's going to have some impacts on traditional ways that we've done things, good and bad. For example, I think the interpreter thing is better than the way we used to do it. Maybe the rule gives us some challenges, but we don't have an alternative at this point except to say, well, if we can't have open courts and we can't enforce the rule, then we just won't have any hearings at all. So we have to figure out a way to do our best given technology, creative thinking, limitations, and just so if you come up with creative ideas, your courts would love to hear about them. Judge Ferguson?
You know, you're exactly right. It's a balancing act. We have competing constitutional issues here. And so it's a balancing between how can we protect both as much as possible. I will tell you that all of these issues, that this decision was not made by a bunch of people who are desperate to be on television. This is not a bunch of media hound judges who just want their face out there. Every one of these issues and all of these concerns we discussed at the very inception of, can we do this? Has anyone ever heard of Zoom? Is Skype better? As we were working through that, we had conversations about every one of these concerns. And so we tried to figure out the best way to balance those things out, to protect here when we can. And we're still, like Judge Miskell said, we're still doing it. We're still adapting every way we can. So we can't just say open courts is only acceptable if no one's actually watching. We have to have open courts that are in fact open. And this is wide open. And I know that we might not want it that wide open, but family law is no different from criminal. Someone is standing there being sentenced to prison and convicted of child molestation. That's pretty personal. They don't want anyone to know. The fact that someone had an affair and that's coming out now, that's personal too. But it's no more important to their privacy than the person who's going to prison for child molestation. So keep in mind, it's not unique to family law. And we are doing the best we can to balance all of these issues and keep justice flowing through this crisis.
What I would
And it's new to us, but courts in Florida are online. I've watched court in Florida. So I know it feels weird to us, but other states do it this way all the time, not just in a disaster.
So, what I would encourage y'all to do that are watching is as the issues come up with your hearings, because again, Texas is so diverse. We have 254 different counties. As issues are coming up in your hearings, let us know. So, we have some universal kind of conversations about what's going on in different jurisdictions, what you found that works, what you found that doesn't work, and have these conversations with your colleagues. I agree. There's got to be some middle ground between it being open to everyone in the world to it being open to no one. And I don't know that any of us are sure what that looks like right now, but if we continue having these conversations, we'll get somewhere where we feel comfortable. So the last part is just to do a couple of tips of offering.
I think we already did those at the beginning. So I think we covered everything on my list from the practice tips.
Okay. Did we share screens yet?
Yes.
We need to talk to them briefly about practicing shared screens. And Crystal, this is something that you showed us yesterday or the day before. I know time has no meaning now, but you showed us this incredibly effective way to share a little bit at a time. And I've been practicing with that for the last couple of days. And I will tell you, it's a game changer for me. If someone puts up an affidavit, and I hope that's what Crystal's preparing, I see the reflection in her glasses, but if someone puts something up that's a document and you share that window and it's your full screen window, then what we get is a little document in the middle with bars of blue or black on the sides, whether it's PDF or Word. And so we have to lean in like this to try to read it. And it's a whole page of too much information. But what you can do is share a portion of the screen. And instead of boxing in the whole thing, you can narrow it in to just the paragraph. And when you share that, it fills the screen again. And so now I can lean back and I can look at the tablet and my notes and I can read it one paragraph at a time. And for impeachment purposes, this is incredibly useful if you're going through an affidavit on impeachment, because you can say, I'm going to show you paragraph 2. Read that. That's not what you just told me, is it? I had a hearing that was all legal argument, and they were flipping back and forth between two chapters. It was a COVID-related case, and they're flipping back and forth between two chapters of two different statutes about what can be done legally. And in the course of their argument, they said, well, Judge, look at subpart A of this one. And now if you look at that one, part F, but go back to the first one. And then if you look at our notice in the affidavit, I can't flip back and forth between 6 PDFs that are 18 pages long and scroll down to subparagraph G. What they could do is what Crystal's about to show you, I hope, and say, here is paragraph A of 104. Now, on the bottom of the page, I'm going to give you paragraph subpart G of 551. And after we read that, let's put up the agenda and I'll show you with my highlighter what I'm talking about. It is more effective persuasion